Have you ever had a client come to you and say, is the contract legal? The laughter tells me the answer, right? You've had that. Have you ever had a client suggest to you, I really don't care whether it's a good idea or what you think about the contract. I just want to know if it's barely legal. Like, will I go to jail, right? I hate that question. Really? I mean, that's not why I went to law school, was just to provide you a checklist. But you need the checklist. And there are times when that's what the client wants, and our job is to look at it and say, okay, it's legal, or here's what's illegal about it. Even though that's not really what I have in mind when I'm reviewing a contract. I think there's a whole lot more value we can add. But we do need to at least get to that baseline, barely legal. And what I found is that in government, there's really kind of three layers, right? One layer is contract law. Have we formed a contract successfully? Do we have a contract? Have we met just those minimum basics, whatever type of contract it is? And then there's this other layer, which is the procurement law, which layers on top of the contract law, and the two do dovetail, right? There's a relationship between, say, responsiveness and contract formation, a meeting of the minds, if you will. And then there's another layer, which is these unique government law issues, some of which are procurement related and some of which are not, that are part of the background law of being a state arrangement, a contract with the government. And all of these are things that have to be checked as a box before you're going to have a valid contract. Now, when my clients ask me this question, one of the things I have to remember is that what they give me to look at is a sterile piece of paper, oftentimes thrown over the transom window after everything's been done, and they just want a quick answer as to whether there's anything illegal. The least useful way to take advantage of having a lawyer with experience on the job, but hey, it pays the bills, right? So, and that's what they want. I don't know whether or not the money is in the bank. We'll touch on appropriations laws. I don't know whether they in fact follow the procurement laws, right? Let's say somebody gives me a sole source. I don't know whether in fact it's a sole source. I don't know whether the person signing it had actual authority. And that's why I think you see a phrase that when I first saw it, when I first started practicing law, always tickled me. I thought, well, what in the world does that mean? But you'll see that there are various people around the country that will use a stamp, it'll say approved as to form. And I'm still not quite sure what it does mean. But basically, if somebody comes to me and says, tell me if it's legal, I'm going to tick off all the things I can't opine to because I don't know. I don't know whether you're spending money you don't have. I don't know whether the person has actual authority, and there are other things. But what I do want to do today is I want to talk about some of the things that should be on your checklist, things to think about when you're looking at one of these contracts. Now, the hard thing about coming up with this list is that every state is going to have a variation, and some of these things aren't written in stone. So, for example, until the last 5 or 6 years, I had not seen any state with an actual statute that said you can't indemnify anybody unless otherwise approved by statute. It was all in AG opinions, right? But what I had heard, I've never researched all 50 states, was that basically all but one state had an AG opinion that said you can't agree to indemnify anybody, which the corporations are like, well, that's just your attorney general. That really doesn't mean anything, right? Now some of that is showing up in statutes. I remember when I started and I asked my boss, well, what can I put on the checklist? And he said, well, I have a checklist, but there's really not a lot of law out there. So, for example, there was not an AG opinion that said you can't agree to the law of another state. But it just seems like a no-brainer. Who authorized me to enter into a contract using Maryland law to apply to the sovereign state of South Carolina, right? And so we said, well, Article 10 of the state constitution, which really just said the legislature can dictate how claims against the state are brought. Well, it doesn't say anything about state law applying or choice of form or anything else. So some of these may be very clear in your state, others may be nebulous, some of them may seem like a no-brainer, but there's nowhere you can actually point to. What I've tried to do is create what I think is not a comprehensive list, but a pretty darn good start, with a plea at the end for y'all to give me ideas to make the list fuller as time goes by. And then I've collected resources for you, AG's opinions from around the country, stuff from the federal government that I think is very persuasive, stuff from the just court decisions from around the country, some of these new statutes that have come out, so that when you come up with your own list, if you're looking for something that puts a little meat on the bones and helps you understand the logic and the reasoning behind that idea, you've got something to turn to. And I first did this for the 2023 NASPO Law Institute Bootcamp, and this is my first try at really updating it. So I'll make a pitch to all of you. If you find this resource, which is in your app and downloadable along with the PowerPoint that I'm going to use, at all useful, then take a minute, put down some of the authorities that you found, and send it to me so I can add it to it for the people who come after us in the years to come, because I think this is going to be a topic, whether it's on the Law Institute or not, a resource that we can turn back to as the years go by. So I broke it out into categories just because it made sense. Contract formation and modification, and some of the things that are unique to government. Some of the critical recurring issues, which is just a pot to put everything into that I didn't have any other place to put. Fiscal debt and security, which is an interesting issue that bubbles up in some contracts. And then lastly, one little assorted at the end, if we have time to get to it. So let's talk about contract formation and modification. So one of the very first things that really struck me about working for the government was this idea that in many jurisdictions, and again, let's go back for a second, just conceptually, every one of you is in a sovereign state. Virtually every one of these issues is a state law issue. That tells you there could be 50 or more different answers to each one of these questions. Right? So when we start talking about what I'll call very loosely alternatives to actual contract formation, like implied authority or ratification or estoppel, or the things that people use to get around the fact that they didn't have a formal, perfect, under the law contract, it's a mess. It's a mess in South Carolina. It's a mess in AMJUR and CJS, and they all but say it's a mess, and that people use different names for different things, and then the courts will confuse them as they do. And so the point of it is you're going to have to figure out on each one of these issues what the law in your state is. What's that single authority that you would point to that says this is the answer on that issue? But if you find that for yourself, this is a good starting point for the issues that you should be familiar with, because if this is what you do, if you're a government contracts lawyer, these are all things that you should have familiarity with. So it is not uncommon for the fundamental law to be that in government you have to do business only with someone who has actual authority to bind the government. Not implied authority, not apparent authority, just actual, you did in fact have the authority to do this. And I like this policy statement from a federal circuit court case. The United States government employs over 3 million, this was in 1990, civilian employees. Clearly, federal expenditures would be wholly uncontrollable if government employees could, of their own volition, enter into contracts obligating the United States. Right? We have a whole lot of people working for the government. We can't have everybody with authority to sign. But as you all know, the law abhors injustice, and it doesn't like forfeitures. It doesn't like the idea that somebody's already done all the work, but you didn't have actual authority. So the laws tend to find a way. But the baseline, the starting point, and the courts in my state have been pretty hard on people about it. The starting point is if you lack actual authority, you're going to have a big mountain to climb to get compensation from the government. So point number one. A related point is, and there's a really interesting case I'll mention briefly, this idea of central purchasing office versus an agency, right? And so I remember how surprised I was when I got a question from somebody and had to do the research. It was a procurement for the lottery's implementation, which was a really big deal when you stand up a new agency and it's the governor's #1 election issue, and the new commission that controls it and the new agency head want to sign a contract. And the question to me was, is that enough? Because they really didn't want the procurement officer to sign it. And so I went and did some homework, and sure enough, it didn't matter who signed it. All of it was irrelevant. It didn't matter if the governor himself signed it. That contract did not have actual authority unless the procurement officer at the central purchasing office signed it. And the case that you'll see in the materials I give you, is on the app, was a fascinating case. It involved an agency that had a statute very similar to the Model Procurement Code statute that centralizes authority in the Central Procurement Office and then delegates some authority to the agencies. So the Central Purchasing Office did a contract for an IBM mainframe on a lease arrangement, an equipment lease arrangement. And the contract was fully formed, it was signed by the procurement officer, and immediately after the contract was formed, the agency signed a new contract with the same vendor for the same thing with one paragraph difference. Now, forget the fact that there was no consideration for that modification. The court could have decided on that issue alone. The issue boiled down to, in the court decision, authority. Now, the clause that was added was a non-substitution clause. So anybody who's dealt with financing clauses knows that when you cancel for non-appropriations, what they don't want you to do is then go buy the same thing with an upgraded copier or an updated computer or an updated mainframe to replace the old one. They feel like you cheated them by canceling for non-appropriations when you still had the money to buy it. So they negotiated to add a clause in there that prevented a substitution of a new equipment. Well, what happened? The contract by the lender got sold. It got sold to another lending company, and then 2 or 3 years later, the agency, what did they do? Cancel it and bought a new IBM mainframe to replace it. And so they got sued by this company that had bought commercial paper on down the line, which is usually the kind of things the courts will enforce. It went to trial, and what did the agency say? What was their answer when they got sued for the substitution? We didn't have authority to sign that. Our agency head didn't have authority to sign that. And you're thinking, there's no way the court will rule for the agency. This is so wrong. Court ruled for the agency. Court said the whole scheme falls apart if anybody can sign, and we ignore this idea that the Central Purchasing Office is the only one that can sign contracts that haven't been delegated. So the lender lost. And that case is in your materials. So this idea of actual authority matters. There's an appellate court case in, I guess, my lifetime where they did it on a big deal, right? In a set of circumstances that seemed very wrong. And it highlights that there is meaning to this idea of the Central Purchasing Office versus the agency. Now, I mentioned what I call these legal contract alternatives, equitable estoppel. Some of these mean the same thing. Some of them don't mean the same thing depending upon your jurisdiction or their variations of a theme. Some of them are very different. Equitable estoppel, implied in fact contracts, implied by law, quasi-contract, which may be both of the prior, restitution, which may include both of the following, quantum meruit, quantum availabant, if I've even said that correctly, unjust enrichment, and then implied authority, which is one that the federal government has developed fairly well. You need to be aware of them because they are other ways to get to you and enforce an obligation or to create an obligation or to get compensation or restitution that otherwise they wouldn't be able to get because they didn't have a contract with somebody who had actual authority or might have violated some rule in forming the contract. Point number 2, contract formation. Wait a minute, we've talked about that one. There we go. This one shows me my next slide coming. All right, so contract formation and government contracts. So before I started in procurement, and again, this is the boot camp, right? So many of you are supposed to be new to this, supposed to be baby procurement lawyers. I know there are a lot of you out here that are old hands, so you'll just have to suffer with the repeat of some old stuff that might be obvious to you. But when I started in procurement, I'd never seen a contract in private practice that worked anything like our contracts. My clients would negotiate a contract and then you would have a closing like in a real estate contract, and there was a pre-printed form contract everybody agreed on and everybody would sign the contract. And I went and I said, we issue these RFPs and these people send back this proposal and then we post this award statement and voila, there's this confusing mess of a contract that's not pretty. It looks like Frankenstein and it bears no relationship to what a contract in the private sector looks like. What is going on, right? And yet that's how we do business. And so I think what we as lawyers have to do is remember that we're lawyers. And we have to take basic fundamental principles of contract law and apply them at every step of the way. You can't just take for granted, well, this is the way they do it. No, break it down, just like you would in a first-year law school contracts class, and analyze it, right? What's the offer? What's the acceptance, right? And when does it happen? Exactly. And it may not be the same. So, for example, I am not an expert. We got experts on federal procurement law that are coming, although I doubt many of them deal with small purchases. But my read is that the federal government, and South Carolina is looking at doing this because that hasn't always been the way we've done things, is doing small purchases differently, where we get the 3 written quotes, and then we attach the winning quote to our purchase order, and then we send that to the vendor to form as our offer to them, which they then accept perhaps by performance, so that we win the battle of the forms fight, right? Versus they send us the offer and we accept it and now it's like, okay, did we actually get some of those important state clauses we needed in it? But that's not how we do RFPs or bids, at least not in my experience, which is we do it a lot more like construction. So there's a ton of case law out there across the country. You might find one in your state, right, to see how it works in your state, that if you are a private entity and you ask for multiple contractors to give you a bid on a construction project and you accept it, right, that acceptance can form the contract. A parallel related idea is detrimental reliance. Right? So if I'm a prime contractor bidding a contract, the subs are supposed to know I'm putting a bid out there that the owner can accept. And if they accept it and you refuse to honor your bid, I can sue you for breach of contract on the theory of not that we signed a formal contract, but you gave me a bid and I had a right to rely on it, and that detrimental reliance served as the consideration, and the courts will enforce that arrangement, or at least give me a remedy for it. And there's a lot of law out there on that because that's how the whole construction industry worked for a long time. Things change. And so the point I'm getting at here is be aware of how those work. I'll never forget the time that I had a lawyer from Coca-Cola call my client, who then came to me and said, oh, now that we've submitted our bid and you've posted the award, we'd like to negotiate. And my client's position was like, we've already got a contract, right? We're done. You submitted a bid, it was responsive, we have a contract, now perform or be debarred and we'll go find somebody else to do the job. And the Coca-Cola lawyer wasn't buying that, so I found a case, it's in your materials, and sent it to her and said, no, this is how this works, and there was no limits on this. When you submitted a bid, but it wasn't crystal clear. We now have clauses that make it crystal clear. When you submit an offer, it is an offer to enter into a contract, and we can accept it. What you need to make sure is you know the rules in your state. And what that court case says is that some states differ. Some solicitations say there has to be a formal written signature. Others say there are other approvals. Maybe a school district board has to vote to approve it, or you have some board in the government that has to approve it before it's a final contract. Just know when you have an offer, you have acceptance, and what those steps are, and when the contract is formed. Because it's different than the private sector. Questions, comments? Feel free to interrupt or ask along the way, because we're going to be changing subjects on each point. And I would love your own war stories. All right, one of my favorite topics in law, in procurement law, is this one, because it's such an incredibly important concept, and yet it's not anywhere in our procurement code. It's nowhere in the model procurement code, and you don't find it until you dig up the court decisions. And our state didn't have a court decision on this. It still doesn't have a published court opinion. We have, like Maryland does, a contract appeals board, and I think a couple of other states might. And so we finally got a contract appeals board decision, and then we said, let's just put it in a statute. So we adopted a statute, which I hope we'll put into the model procurement code before it's done, that just states this very basic principle. But you know it, right? You know it in your gut. You can't put out a contract to award somebody you can't procure and award somebody a contract for 50 cars and then add a box of pencils to it, because that's got nothing to do with what you just bid, even though the box of pencils may be $2. And you can't put out a multi-million-dollar contract to build a new stadium and say, by the way, I need $100,000 in automobiles. Well, $100,000 is minuscule to a $30 million contract for a construction project, but just because it's minuscule doesn't make it an appropriate change to that contract. You didn't bid anything to do with it, right? That's called the material change doctrine. And you'll find it in the case law. In fact, the very best case is very uninteresting on the facts that I have ever found, but the model procurement code, which your state may or may not have, Alaska is a model procurement code state, and the very best case I've ever found on that topic is the Kenai lumber case, which is in these materials, a 1982 Supreme Court decision from the state of Alaska. And they look at decisions from all over the country, and they pull together all these different factors that courts have considered, which are not an exhaustive list of factors. It's just a way to illustrate you're looking at the totality of the circumstances. And then they explain this fundamental idea that material amendments are not allowed to a contract that the law requires be competitively bid. Now, in 2023, I made an assumption, and I was wrong in the 2023 materials, so I edited them, because I spent, an hour and a half, 2 hours, and if anybody out there has anything on this, I'd love to see it. I couldn't find a single case anywhere in any law review article, case, administrative decision that dealt with the idea of applying a material change doctrine to, say, an emergency contract or a sole source. But I don't think you can sole source and say, I can never change the sole source at all. I don't think you can sole source and say you can then go add anything you want to it, right? Conceptually, the idea still has to be there. Do you have to do a sole source for every change order to a sole source? I don't know the answer. I don't think it's gotten a lot of litigation, and if it doesn't get litigated, it doesn't tend to bubble up in the materials, right? Because we write our law review articles about what the courts have said. But I think the idea, the conceptually applies. And so the question is, what makes it material? And what the Kenai lumber case says, and what most of the case says, is that what really matters is it's material if it's at odds for the reasons we have public procurement. I remember when I first got to my job, the commentary, there was like if your experience may be different than mine, and of course if you're really new at this, you may not have a feel for this yet, but there's definitely a culture inside a state central contracting office. There's a mindset. There are assumptions, particularly if there hasn't been like radical staffing changeover. You develop these rules of thumb, these assumptions, these beliefs that people have. Like, I'll never forget going to an annual conference of NASPO years ago, and the chief procurement officer from Delaware and Massachusetts, I can't remember their names, put on a presentation to shake up the room and challenge one of these enduring assumptions in government contracting, which was you can't talk to the vendors, right? And in fact, that assumption is so widespread at the federal level that the OFPP, the Office of Federal Procurement Policy, came out with what's called a Mythbusters memo. There were several. And one of the points it made in the Mythbusters memo was not only can you talk to the vendors, but you really must talk to the vendors. It's essential you talk to the vendors. And yet the working assumption, the mindset of the entire acquisition community was so anti-talking to the vendors for fear of corrupting the process of giving somebody an unfair advantage that people didn't talk to the vendors, right? Well, I found a similar kind of institutional mindset in my state when I came on board, and the general internal thinking was, if you want to change the price more than 10%, it's a material change. Well, that's hogwash, right? That's just hogwash. It has all kind of problems in it. It's overly restrictive in some sense. It's inadequately restrictive in others, right? Thus, the pencils or the cars on contracts of much greater magnitude. But what you've done is you've changed the overall nature and intent of what you're buying. I mean, they're just, so what's the rule? I don't know about y'all, but when I was in law school, one of the things you did was you would pound the table if you had the facts. I mean, you would argue the facts if you had the facts. You would argue the law if you had the law. You would argue policy if you had policy, and if you had nothing else, right, you just pound on the table and quote scripture. All right, I'm from South Carolina. Well, in some areas of procurement, the law is the policy. Right? And so, and it says it right in the Kenai lumber case. And I'm not going to read a lot to you, but this one I'm going to read. Not all amendments to competitively bid contracts are prohibited. Only those regarded as material. Well, I mean, that's like the, substantial material. Don't you hate those words? You're like, what does that mean? Lawyers love to use these wiggle words, the courts do. So how do you infuse that with some meaning? How do you practice law? How do you tell your client, yes, this is a material change in my opinion or not, and here are my reasons why, and when you finish talking, they're like, damn, that makes sense. Rather than, I can decide what material means as well as you can. You're not helping me any, you're just an overgrown English major, right? I mean, really, what is it that differentiates us from an English major? It's knowing what the law is, and one of the things the law is policy. So let's keep going with the court's quote. The concept of materiality in this context has not been satisfactorily captured in a single phrase. One court has spoken of, quote, an essential change of such magnitude as to be incompatible with the general scheme, close quote, of competitive bidding. Another has phrased the question to be whether the amendment, quote, so varied from the original plan was of such importance or so altered the essential identity or main purpose of the contract that it constitutes a new undertaking. Okay, I'm still feeling like, okay, where is this going? These formulations simply recognize that the materiality concept prohibits those changes which tend to be subversive of the purpose of competitive bidding, the purposes. In determining whether an amendment has this tendency, courts have found the following factors to be of importance. The legitimacy of the reasons of the change. Have you ever had a client who wasn't convinced that the reason for their change was legitimate? Okay, think about it, right? Whether the reasons for the change were unforeseen at the time the contract was made. Well, we didn't think about it. Really, you knew that federal grant money was out there and that you wanted to use it for this contract. You just, the timing of the change. Oh, we need to make this change the day after award, not 5 years later into a 15-year contract. Whether the contract contains clauses authorizing modifications. Well, we'll just put a contract clause in our contracts to say we can do anything we want in this contract and add anything we want. I've had clients actually do that because they think, well, if I do that, I can do anything I want. Doesn't matter what we competed, doesn't matter what we advertised, right? That's not dealing with the policy the court's talking about. That reminds me of a recent court decision my state Supreme Court made where they adopted the restatement's second factors for what is a material breach. Right? There you go again. There's that word, material breach. How many licks does it take to get to the center of a Tootsie Roll Tootsie Pop? Remember that? Right? Well, crunch. The world may never know. Well, I tell you what, anytime somebody asks me, I'm saying, well, we'll have to wait till the judge finds out. Do you want to find out the hard way, or do you want to work with the vendor until it's absolutely too painful to continue? That's usually when people pull the plug, right? I would rather take the risk of the judge concluding I breached it by terminating the contract than to continue this performance so it's so painful. People avoid the gray zone because nobody quite knows what material is. Because judges don't like a forfeiture, right? So we're familiar with this concept from law school of materiality. And really, it's this whole set of policy issues you have in construction law. And I'll come back to procurement in a second. But think about the parallel here, right? Your expectation interest. How badly is the other person going to be injured? What remedies are available? I mean, there's a lot of different elements a court will look at, and the restatement second articulates some of them, that you use to decide whether a breach is material. And the court came out and point blank and said, just because you say in the contract and the party agrees this will be a material breach doesn't make it material. That might help us think it might be material. That might weigh or tip the balance. But at the end of the day, just because you say it's material doesn't make it material. We're going to tell you what material is. And they've done that for a reason, right? When the law decided it was going to be a perfect tender rule, like the Uniform Commercial Code, they adopted that as the statute, as the law, because there was a policy that justified it, because that's how people do business on transactions for the sale of goods. But in everything else, we'll tell you when it's material. Well, you got the same problem over here. The court is pointing to a set of factors as to what's material. So what are those factors? And at the end of the day, you look at it and you go, does this undermine the reason we have an open and competitive process? And there's lots of reasons for that. You can open up the Model Procurement Code and look at the purposes and policies, and that's a good start. So one of the factors that I think you need to hear about that is an interesting one is one that the feds adopted years ago that has come under increasing criticism, and there's a fascinating article cited in the materials here that says, is this a valid test? But it's written by one of the 2 or 3 people that work at or write for a publication called the Nash and Sabinic Reporter. And Professors Nash and Sabinic were the 2 guys that founded the George Washington Law School's government contracts law program. They if you haven't bought any of their textbooks, I'm telling you, buy Administration of Government Contracts and Formation of Government Contracts. They're textbooks on government contracts law, but they will teach you so much. Best money I ever spent once I joined the state. In any event, he wrote, one of them, Vern Jones, wrote an article called Scope of Competition Test, Is It Still Valid? But one aspect, one way the feds look at this idea of a material change is, would the field of competition have been affected by the change? So I'll give you an example that's come up in South Carolina several times on big deals. How many of you think that you can get a major IT contractor to enter into a major contract with your state for an IT service with no limitation of liability clause? Raise your hand if you think you can do that. No hands. Okay, so the state puts out a procurement and says there is no way we're agreeing to any limitation liability. You ever seen that? I love when agencies do that, right? Completely unrealistic right out of the box. They're told, they're like, nope. So you put it out, and then a Q&A comes in and says, will you agree to limitation liability? Nope. And then a few people who've been around and know that you're going to cave when it actually comes to it, submit a proposal, and your state has a process that will effectively allow them to cure it in some way, shape, or form, because all our procurement rules have little variations. So you get to the end and you negotiate a limitation liability clause in there, or hell, you do it after award, which is when the material change doctrine comes in. You make the award, and then they come right to you with the change order request and say, we'll cut your price by 15% if you'll take out the limitation liability clause. Or hell, they'll do it without consideration. They'll just bend your arm and twist and sit on you until it happens, or they'll call it an elected official. And so you give up the limitations and liability clause. Well, do you think that might have affected the field of competition during the competitive process? I'm seeing heads say yes. How about this one? How about you go out there and you ask for a performance bond on a multi-million-dollar, multi-year IT contract, and they're going to have to pay for that. And in construction, where performance bonds are routine, the relationships exist, all the indemnity agreements that have to take place between the contractor and the surety are already set up this is business as usual in construction. In IT, it's not that common. And so not only is it a lot of effort to set it up, but it's expensive, a lot more expensive than it is construction. Like it's percentage points, right? So it's percents of your contract total value. So what does that do to their price? It sends their price up. And what do we always evaluate? Their price. And so now I put one out there. Do you think there's some vendors who aren't going to bid because they're not going to try or they can't get a performance bond? And then you come in during negotiations, during a best and final, or same basic concept here, after the contract is signed, and you're like, it's IBM, they're never going to fail, they're credit worthy, I don't need a surety bond, we'll save $200,000, we'll just do a change order and take the performance bond out. Do you think that affected the field of competition? You knew about it before the contract was awarded, you make the change right after the award was done, it modified the field of competition. You've got to, if you're going to say that's a material change to your client, you can't do that, you can't save the $200,000, you better be able to explain why in a way that I'm not just an English major, I'm a procurement lawyer and I understand how this works and why it works, and I can give you cases that explain it and say that's a material change, because you'll never find a set of facts on that exact circumstance. But you need to explain it to your client, because I think you're going to lose that set of facts in court, at least based on the cases I've read. Now, maybe you'll find a better case than I have. Anyway, it's one of those things that, frankly, I practiced in procurement for years, just assuming that the 10% rule was right. Shame on me. So the idea of this whole boot camp is to give you a head start on some of the things that hopefully you'll learn a little earlier, that you're like, nobody ever told me that, before you run across the problem. Now, you'll at least remember to spot the issue in your practice. All right, this has become a really interesting issue, and I'm going to explain why, but let's just start out with the basic concept, right? So I'll give you a set of facts. Happened in South Carolina, and that's what led me into this particular rabbit hole, right? So we have a contract for child support enforcement. Big deal, right? If anybody has heard about it, if you're young in your states, this is old news, but back when I came along, these contracts went on for a decade. They cost enormous sums of money. Many of them failed. Every state had to do it. If you didn't do it on time, the federal government penalized you with massive federal penalties. It was just, it was one of these massive IT projects that was just troublesome. Bound to fail, bound to have problems, bound to have cost overruns, get a lot of public press and a lot of attention from the General Assembly. And the contract was signed by, I never saw this contract, but I knew that there were multiple agency heads on a committee that was driving the contract. So I'm assuming that at least one, if not multiple agency heads signed that. The Chief Justice happened to be one of them. And we had a private lawyer come in and negotiate it. It didn't look like a government contract. It was one of these corporate, a law firm did it, looked like a standalone formal contract document. Everybody had signed it, and guess what it said? Any disputes go to state court. And all the procurement officer had signed it, right? Everything had gotten a lot of attention, a lot of focus. Years go by, project completely fails, everybody's unhappy, and everybody sues everybody. And the vendor sues us in state court. And the state sues the vendor before the chief procurement officer in a little, let's go to a very tiny conference room and have a protest or a contract dispute in a room with a person who's not a lawyer, who's the chief procurement officer for the state, and their sidekick lawyer that gets no respect from the big corporate counsels. And I'm just making a funny picture, right? It's like this multi-million-dollar lawsuit, and the corporations are like, you think we're going to try it in this forum? Or is this a joke, right? No, we're going to court. Goes all the way to the state Supreme Court. And the state Supreme Court, and I was the lawyer sitting with them, by the way, so, I was the guy making fun of myself. So the thing goes all the way to the state Supreme Court, and the state Supreme Court says, wait a minute. There's nothing new here. For generations, we have been saying if the General Assembly passes a statute and says, this is the law on insurance. Like, I'll give you an example. We used to have a state statute that said, you will provide coverage for parents who have autistic children. Well, then, if you write a health insurance policy in South Carolina, it's in there. It doesn't matter whether you put anything in the contract or not, it's in there by operation of law. The court said there's nothing new about that. We've done this for a long time. The General Assembly has passed a mandatory statute, and it says this is how you enter into public contracts. And it says the exclusive means of resolving a dispute on public contracts in the state of South Carolina is here. We don't care what the contract said. To the extent it was inconsistent with the Consolidated Procurement Code, the Consolidated Procurement Code is part of that contract as though it was written in it, and it supersedes anything to the contrary. Doesn't matter who signed it or what it said. I was like, oh, wow. That's nice to know. That's this basic concept that's been around, that the law applicable to a contract at the time and place of its making, and maybe of the place where it's performed, I don't know, that's a little broader. This is the CJS, which is usually a little loosier-goosier, is an implied part of the contract. Now, I haven't found another case at the state level that says as directly as South Carolina says it, that those implied terms supersede any terms at odds with the law. I'm sorry, I didn't say that very well. The implied terms by operation of law supersede any terms in the contract to the contrary. I think I mistyped it. So, I like this one. Amger second says it a little better. A person who contracts with a state, because when nobody should ever stop their research with Amger or CJS, right? They're kind of basics, but they're good general statements of what has long been the law in the country. They're always good starting points for research. A person who contracts with the state is chargeable with knowledge of the statutes that regulate its contracting powers and is bound by them. And those conditions need not be expressly stated in the contract. Now, I'm not going to try and give you any thorough explanation of this, but there is a related concept which my state Supreme Court cited in this particular case I'm talking about, which is in your materials, the Unisys case, has this idea called the Christian doctrine, right? And to grossly oversimplify the Christian doctrine, the federal government promulgates a lot of its contract clauses in the Federal Code of Federal Regulations. And the federal courts have said, if you have one that's particularly important, which is a mystery unto itself, right? But if you have a clause that's particularly important, it is in the contract even though nobody references and the procurement officer forgot to put it in there. Like a disputes clause might be one. And it controls. So in effect, it's not quite the same as what you find in the state case law and the common law, but that concept does exist at the federal level. And I will tell you that here are the places I run into it. And if anybody's got any additional examples, shout them out. I'd love to hear it. Prompt payment. Right? We have a state statute that dictates exactly when our minimum time to make payment to the vendors is. Interest on late payments. We can't agree to any amount of interest on late payments other than what's expressed by statute. These are ones that you might look for if you're not aware of them in your own state. Do I have these, right? And then you might say, well, are there others? And this list, by the way, is in everything. I've written up a 16-page document for you that you can take home, and it has all of this. Another example might be choice of law, although we never had one in South Carolina. Choice of forum, or otherwise how claims against the government are made, or your waiver of sovereign immunity and whether it's limited and what the scope is. How about non-appropriations? In our state, it's written verbatim right out of the Model Procurement Code, right in the statute. So our clause is exactly what the statute says. Legal representation of the state other than by the Attorney General, because in my state, the Attorney General has the statutory authority to take over any litigation where the state's a party. Doesn't have to. So does that automatically form a part of the contract, even though it's in a completely different title and most state lawyers don't even know about it? Tort liability other than the scope of the Tort Claims Act. I mean, you can go on, and that one's going to come up a little later in the presentation, but if the Tort Claims Act is the exclusive means of having a remedy in tort against the state, can you agree to broaden that by contract? Does that not also form a part of your contract if it's mandatory and an exclusive means of bringing a tort action? Those are just a few examples. One of the things that I told you, this has gotten a lot of attention lately that I think you ought to be aware of, because if I were to snap my fingers and do one thing for the entire procurement community, right, if I just was king for a day, it would be to do this for everybody. So do you ever get one of those licensing agreements and you don't have enough negotiating power to even get the vendor to take your phone call because it's riddled with illegal terms and conditions that you can't agree to? Yeah, I'm seeing some head shake. Those drive me crazy. Well, what if you simply had a statute that listed for your state all the stuff that makes it illegal ab initio, just as kind of a government issue, like the issues we're talking about today, right? Like the exclusive forum of bringing disputes in South Carolina, and no, we do not agree to Texas law, and we're not going to Argentina to, to litigate this thing. Wouldn't it be great if you could wrap all of those in a beautifully drafted statute that said this forms a part of every contract and it supersedes and the rest of the contract remains valid? I can tell you a lawyer in every major agency in South Carolina state government that would instantly get hundreds of hours a year of their life back because they could just ignore all those issues and quit fighting about them and do something more important and more productive. I'm seeing some shaking heads, which usually means I'm not talking to myself. The idea is resonating. Well, guys, South Carolina has done it, and I did a poor job. I wasn't bold enough to ask for everything I wanted. I was so impressed with a friend of ours that used to come to all of these and be on the planning committee, McCall from Georgia. Georgia has a better one than South Carolina's. I'm rewriting ours right now because we may go to the legislature in the next couple of years. Colorado has a good one that inspired me. I think Idaho has one. And then in here, I also put down a clause drafted by the United States General Services Administration for a clause they've drafted to deal with this concept that I encourage you to look at, because we're starting to do what I call defensive drafting, where we put a list of anything in your contract that says X is void. Just kind of a one clause at the end that we try to put in to deal with the stuff we don't anticipate. I got a question or comment.
So my name's Sam. I'm from West Virginia. We have a statute that has a list of everything that is void ab initio. So we do use it. The issue that I have run into is that our Attorney General, who approves things as to form, will reject contracts if they have terms in them that conflict with our void ab initio clause. So as opposed to getting all the time back, we're having to just re-argue with all of the vendors about how their terms can't conflict with 5A362. Does that kind of sort of make sense? I mean, it doesn't make any sense, but.
It does. We tried to deal with it by drafting something that basically said, that tried to draft around that by trying to convey you don't have to take them out. The contract remains valid, and they're simply carved out by operation of law. I think we're going to get better at this as we go. I would like to have a conversation during the Model Procurement Code project about this. I don't know whether industry and the states will see eye to eye, but even if we got halfway there and took half the issues off the table, or even a third of them, I'm not sure we'll get agreement on this. It may just be something that states have to do, if not contract by contract, statute by statute, but food for thought, right? There's a possible solution to make it more efficient. Yes.
Sorry about that. So what Colorado did, because we have a similar statute, is our central contracting office has a policy about how we have to follow if we're gonna argue to keep the terms in. So we have to submit a form to our central contracting office to say like, hey, will you approve us leaving them in? But as part of that, we have to make sure we've notified the vendors. These statutes exist. These things are going to be void. We'll agree to keep them in, but just know this. And then we get approval from our central office, and there's a whole policy and formal process around getting that approval. So I'm from an agency, so I can't just do it myself. Like, we have to get that approval. So that's how we've dealt with it.
So I'm glad it sparked a little conversation. It's a big deal because it obviously takes up an enormous amount of time and resources. If you have a statute like West Virginia's, I wish you'd email it to me. My email's at the end of the slide deck, or it's at the end of the 16-page handout. If you have one of those checklists, I'd love to see it. I've often wondered, I've got several attorneys in higher education in South Carolina that end up looking at a lot more little contracts, right? They're like, just the volume of contracts they deal with is massive. And they use those letters. I keep asking myself, if you don't have a statute on every one of those points, which we don't in South Carolina, how can I be certain it works, right? And I haven't gotten an answer that convinced me yet on that issue, but it would be so much easier to just have a state statute, because now, in fact, the statute can say, this is part of the contract by operation of law. You can spell it out. You don't even have to have somebody go read Williston on contracts or a state case law that says these terms are implied by law. You can put it right in the statute. Just make it clear as a bell, right? Nothing wrong with being obvious. Anyway, interesting issue, and please do send me your list or any ideas you have to add to it. All right, the next category, critical recurring issues. So,
hey Keith, before you move on,
please.
I've got a question. Can you talk about the material change doctrine applicability between the state's RFP that includes a form professional services agreement and the actual contract that is negotiated and executed with the awarded vendor?
Read it one more time. Or if somebody
Yes.
here wants to elaborate who asked it, go ahead and jump in.
I'll elaborate. It was
Please.
my question. So you were talking about the material change doctrine mostly with contract amendments. So I was curious if, for instance, the state puts out an RFP and we provide our form, contract as a part of that, and what actually is negotiated and executed is substantially different than what was advertised in the solicitation. So I was just curious how that doctrine might apply to those two sets of contracting documents rather than material changes in the contract through the contract itself.
That's a great question, and thank you for the question, because I kept going back and forth, as I tend to do, between different concepts to use similar concepts in a different arena to illustrate how one works. But the material change doctrine has no applicability until a contract is formed. So then the question becomes, what's the rule beforehand? Now, I can't tell you the rule in your state, right? Because I don't know what your statutes say. What I can tell you is we have a statute that I think is modeled after the procurement code that says we have to provide adequate public notice of our contracts. Okay? Now, many of you in this room may disagree with me on this, but in my mind, an advertisement that says we're buying stuff doesn't provide anybody adequate public notice of anything, right? And if I went to the various other notice statutes, you have to give notice of bonds, you have to give notice when you're taking somebody's property because you can't find a property owner, on and on. There are other places in the law where you have to give people notice by publication, for example. You can't just say, hey, we're selling a piece of property. Figure out where it's at, or click on this link and go look at the map and figure out where it's at, right? The whole point is we put out a whole, just like the federal government has a website where they just reams of documents out there telling you all the contracts available. If it's just click on the solicitation and go dig in to find out. That really isn't adequate public notice in Keith's mind, okay? Because you haven't met the whole purpose, to foster competition, to give them notice of an opportunity to do something that they might be interested in. In other words, it's supposed to be a bait on the hook to get them to go look at the solicitation and make a bid or no bid decision. Well, I don't think I can put out a notice that says I'm building a $30 million building and then modify the solicitation to buy 12 cars and not build the building. You with me? So in our statute, what it says is that you can negotiate changes within the scope of the RFP, okay? At the federal level, at the state, at the material change doctrine level, there are some court cases that say that the material change doctrine is you can't make a material change to the scope of the solicitation, or the scope of the contract, rather, right? And then in construction, there's other concepts of changes within the scope. Each one of them is nothing more than this idea of materiality, right? How much can you change it at any point in the process before you've changed it so much that you've undermined the reasons we have public procurement rules? And I don't want to be the guy who goes to court and says, we put out an RFP and we said, it's this way or nothing, and then we changed it radically over this. It's always a matter of degree. And every state has different rules about the degree of flexibility it has in, do you even apply the concept of responsiveness in an RFP, right? How do you evaluate? How much do you have to have an apples to apples comparison versus an apples to oranges? How much can you change it, right? So in my state, you can do a lot more of a change in a best and final than you can negotiations, because in a best and final, everybody gets to bid a best and final before you complete your evaluation. So it's more competitive. It really depends on the facts. There is no universal answer I have found that deals with the scope of change prior to award, but I think conceptually it's very close to this idea of, is it material? Did it undermine the procurement process? So great question, no good answer.
No, that was good, thank you.
All right, so termination for convenience. Just looking at my time here. We got plenty of time, so I can't believe I'm actually going to fulfill her prognostication that I'm going to use all the extra time, because I was going to throw something at my friend back here in the corner who laughed when I said that, when he laughed when she said that. So termination for convenience. So termination for convenience is not unique to government. It started out being largely unique to government. My recollection, has been a long time since I've read the history on it, was that it started out during the war years when you had the industrial base had to be fundamentally shifted to the war effort. So you had automobile plants making, making tanks. And the government needed to be able to, when the war ended, to stop, right? Or we don't need tanks anymore, we need planes, so go make planes. Anyway, the construction industry has largely adopted you find termination for convenience some in construction. There is an anthology of commercial terms I found on the website, on the internet, maybe 15 or 20 years ago, where somebody went out and found all these different corporations and pulled together their standard terms and conditions, and a number of them had termination for convenience clauses. So it is not unique to government. I think it gets more attention in the case law of government, perhaps because there's one database for government, right? And research and contract law is a little more nebulous. I've never found an AMJUR entry in the non-government on termination for convenience clauses. But I can tell you it's routine. And I'll just offer you not much about this one. Wait, I haven't even put it up yet. The one thing I will tell you is the fundamental law that I have found is you don't have a right to terminate for convenience, almost a no-brainer, unless you put it in the contract. And the other one is the only real limit on your right to use it is good faith, which is a very typical, right? Every contract is an implied obligation of good faith and fair dealing. If it's the model procurement code state, I'm not sure, I'd have to check. I think it's in a model code provision. I know it's in ours, that every contract is an implied obligation of good faith and fair dealing, kind of a UCC idea. We're going to come back to the idea of good faith, but I want to make one plug for this. I think it is valuable for you to advise your clients that putting this by default in everything they do is a bad idea. It costs money. It drives our vendor pool away. There are people who, I've talked to contractors who simply won't do business with the government. I think the most dramatic example of this I had was I was going in to meet a family member for breakfast at, get this, the restaurant name in Columbia, Lizard's Thicket, which is a great place to have breakfast. And you're only going to find Lizard's Thicket in South Carolina. And one of the contractors who was in the Association of General Contractors, in fact, he was the president that year in South Carolina, the AGC, and I stopped by to say hello, and I asked him if he bid government contracts. And he said, because we had been negotiating on changes to the procurement code with the construction industry, because they have a powerful lobby and you can't amend anything in the procurement code that affects construction without getting their sign-off. And he said, no. It's too much of a pain. The profit margin is too narrow. There's too much contention. It's all low bid. We're competing against people who don't do as good a job as we do. And you got all these contract risk allocation devices that we don't like termination for convenience. So I am probably the number one voice in central state government purchasing that beating the drum that don't use this unless you need it. Why would you put out a contract to buy 5 backhoes and put a termination for convenience clause in it? And yet I've seen it. Okay, here's the one thing I do want to warn you about on termination for convenience. Bad faith can be in the eye of the beholder, and I've learned that the hard way, right? So if you look at Amjur on public works, it says, as an example of bad faith, terminating is simply to acquire a better bargain from another source. That doesn't sound like bad faith to me. Extorting them for a price discount might be bad faith, but just wanting to go to a different source because I don't like them and they're not doing a great job. But here, that's an example Amjur gave, and usually when Amjur gives an example, I'll bet there's a case out there with the footnote in it giving you an example where a court found that was bad faith. So before you give your client a green light to terminate for convenience because they're going to hang their hat on you, right? Go look for, what do? We find cases with similar factual scenarios to ours before we give the client an opinion they can hang their hat on. Because bad faith, again, is in the eye of the beholder. All right. Sovereign immunity contracts and tort claims. Know like you breathe, like you wake up in the morning, right? One of the most important things in any relationship is who's going to decide where the fight takes place when there's a fight and what rules control that fight. I mean, really. Secondary only to knowing who you're fighting with, right? Which is always amazing when my clients don't actually know which corporation they've entered into a contract with, right? They think it's Coke and it's some wholly owned subsidiary's a sister company with no capitalization that they've actually contracted with. But know your state's rules, and don't just know it for contract, because it's very common for the scheme for sovereign immunity and tort and the dispute resolution process and the forum to be very different than it is for contract. So you need to have at least a working knowledge of the basics, right? And probably a very extensive knowledge of how it works on the contract side. And then that's the basic question to ask yourself. That's the issue spotting. Where I want you to dig in a little bit more is I want you to realize that there are layers to complexity here that you probably want to know. So just to kind of illustrate the problem, how do those two forms overlap, right? So you might have a case that involves a contract relationship that has failed, but one of the grounds for the government is, wait a minute, you made a material misrepresentation to us. You defrauded us in the inducement of the contract, and you defrauded us when you filed a claim. But really, this is all about breach of contract, right? This is a contract claim. Well, so which form is going to control? I will tell you, I have looked in my state, and I need a crystal ball, really, to figure out to make a logical argument to a court as to what is the scope of the authority of the people in the forum on contract versus tort. And just to quote from an ABA Public Contract Law Journal article from 1993, a contractor may not bring tort and contract claims against the federal government in the same forum. Well, really, I got to go litigate this in two different forums with the same basic set of facts arising out of one set of facts? I mean, hell, I was taught in law school that everything arising out of one set of facts had to be brought at one time in one forum. I can't even remember the rules of civil procedure. It's been so long since I practiced in circuit court. But I remember this basic concept, and here I got to break it into two different forums. Well, that begs the question, do you know in your state what the basic framework is for those two different scopes? And then it gets more complicated. So, for example, in my state, once upon a time, sovereign immunity was a jurisdictional bar. Not anymore. Now it's an affirmative defense. And we've hired, I don't know about you guys, but listen, maybe you've got an AG's office with experts in government contract claims that's what they do. But in my state, the Attorney General's office doesn't want to have anything to do with these private disputes on contracts between agencies and the contractors. Or if they do, it's a sideshow for an AG that has a full-time job doing something else. Your state may vary, right? I know there are other, I remember the first AG I met from another state at an ABA annual event, and there was a lawyer in the AG's office at that state, and all they did was deal with breach of contract claims for the state. And I was like, damn, I wish we had one of those, right? But in my state, these breach of contract cases often get outsourced to outside lawyers. And guess what? None of them know almost anything about sovereign immunity. And they don't know that you have to plead it as an affirmative defense or we lose. They also don't know that failure to raise the exclusive forum, right? So I told you my state court said, you're out. Remember that example where they signed the contract and it went to the state Supreme Court, and the state Supreme Court said, doesn't matter that you had a choice of law clause, a choice of forum clause that said go to circuit court. That's illegal. Go back to the chief procurement officer. But in that case, when we wrote the motion, we filed a motion to dismiss for failure to exhaust administrative remedies. The court said, yeah, the statute said it's the exclusive remedy. But they also cited a case that said, but if you had not raised the failure to exhaust an administrative remedy as an affirmative defense, you would have waived it. And the circuit court is a court of general jurisdiction. They could have heard it. All the difference in the world. And I don't know about y'all, your practice may differ, but every time there is a government contracts law case, a big one, somebody calls my phone, right, at the central purchasing office, because the lawyer at Department of Corrections and the lawyer at DSS and the lawyer at they don't do this. This is not their world. Their world is all the stuff they deal with specifically there. And so they call me or they call another lawyer in my shop. We're the experts on it because nobody else is knowing it. So if you're not, who's going to know that it's an affirmative defense or it's a jurisdictional matter, and that if they're tort claims, someone needs to be thinking about what forum they can take that dispute in. So just something I think that's worth you having some awareness, which dovetails very closely with this one, which is forum selection. And really, I think I've already covered everything in this slide. Just being aware that there's a rule on it. So I'll go to the next point, which is one that's always been kind of interesting. So I had never heard of the 11th Amendment when I graduated law school, and I'd never heard of the 11th Amendment when I started practicing the state until something hit the fan. The 11th Amendment, it's not actually a jurisdictional bar, although sometimes the courts treat it that way, and sometimes they treat it as something that you have to plead. And the federal court decisions are not always uniform, or at least the ones I've looked at haven't, and I haven't kept up at it with the granular level over the years. So I'm not a master of the 11th Amendment. There's a lot of law out there on it. Mostly what I want you to do is get the basic ideas and be aware of the issue. And the fundamental idea is that absent some exception, like the Congress has passed a law that abrogates sovereign immunity by the states under the 11th Amendment, and they have the constitutional power to do that because the Supreme Court has said in some cases the Congress can't do it, even though they've tried. So absent some exception or a waiver, which we'll come back to in a second because it's easier to waive it than you might think, contractors can't sue state-level entities in federal court. You're like, well, why do I care? I don't know about you guys, but once I realized that all these IT companies could not haul us into federal court in wherever they are, anytime they want to on a dispute to get money from us, because the 11th Amendment doesn't necessarily apply if they're just trying to get an injunction against you. There's a nuance there I'm not going to dig into today. My concern with spending a lot of time negotiating what used to be more important, which were intellectual property indemnity clauses, became a lot less worrisome. Right? The whole idea behind IP indemnity clauses was, hey, you're selling me this IT, and one of your other customers, somebody that you stole this from, is going to sue you, but they're also going to sue all your customers to put pressure on the IT provider, the IT owner, to stop using the IT. And so they're going to rope us into the litigation. And I want you to indemnify me for that. And we used to work, our chief procurement officer of IT and CIO's office was very worried about that. And once I learned, well, wait a minute, they can't haul us into federal court, and the exclusive means of resolving a dispute is before the chief procurement officer, I was like, I'm not worried about this. I'm not going to spend that much time on it. It's understanding where you're going to have the fight. And not getting hauled into federal court in some other state is a big deal. It's very expensive. And so you just need to be aware that there is an 11th Amendment, and you don't want to do anything to waive it. And if you're going to contractually consent that your sovereign state can be hauled in federal court, I would make sure that someone gave you the express instructions to do that. So the other one is getting sued in another state's court. And it wasn't that long ago. Let's see, it was 2019 that the U.S. Supreme Court changed some prior law and held in Franchise Tax Board of California versus Hyatt that states retain their sovereign immunity from private suits brought in the courts of other states. So you can't haul a state into the state court of another state. So Microsoft has no right to bring us into Washington state courts to sue the state of South Carolina, and that wasn't the law before 2019. Unless you waive it, you consent to it, in your end-user license agreement that they won't negotiate. So let me give you one example of a set of facts that worries me. So there was a 2015 case where Oregon was found in the District of Oregon Court to have waived their immunity by contract under the 11th Amendment. And the court found it in a decision that basically was a venue provision, right? Which basically was like, if we do have a lawsuit, venue will be in the federal or state court in Oregon. The court said, you waived your 11th Amendment immunity. Now, since then, there have been some decisions that would suggest that the Supreme Court requires a tighter standard, a more express waiver of the 11th Amendment immunity, but I don't want to be the guy to be the test case. One of the questions that continues to worry me is if the state were to enter into an arbitration agreement, and that arbitration agreement were governed by the Federal Arbitration Act because it was interstate commerce, have I now effectively consented to an appeal or a challenge to that arbitration in federal court and waive my 11th Amendment immunity? And I've been unable to find a court decision that talks about it. And that takes me to my next issue, which is arbitration. And there are really two things I want you to come away with arbitration. My state has an AG opinion that I fundamentally disagree with that just says, yes, the state agencies can enter arbitration agreements. I'm like, wait a minute. Arbitration usually means binding final decision, not mediation, but arbitration. Now, they didn't really make a distinction between binding arbitration and non-binding arbitration, but in my very limited experience, arbitration usually means the final decision. Well, if the General Assembly has said the exclusive means of resolving a dispute with the state on a contract is before the chief procurement officer or before a procurement review board, like a contract dispute board, I think is what Maryland has, maybe, how can we agree to arbitration? That's like saying we're going to withhold documents even though FOIA says we have to reveal them, we have to release them, right? At some point, the law should control. Well, you got to decide or figure out in your state whether your agencies have authority to enter into arbitration agreements. And some of them may be doing it. I've been surprised to find some are doing it that I wasn't aware of. But more important, if you do it, take the time to figure out some of the issues that are involved in arbitration. Because I've talked to a few lawyers that do a lot of arbitration in private practice. And here's what one of them basically, in fact, he was a guy I hired who'd been in private practice for 30 plus years before I hired him to spend his last 13 years of practice with me. And here's what he wrote up for me. Looking at basically some of the rules, the general rules, I can't even tell you the names of the people who come out with these general rules of arbitration. I think there's some that are industry specific like construction. The American Arbitration Association may be one of them, right? But he said, Keith, this is basically a summary of what arbitration is. The arbitration process is essentially secret. Okay, public contracts resolved in secret. That's going to work well in the newspaper for my elected officials. Arbitrators can issue court enforceable judgments and orders against public entities. Arbitrators are not required to correctly interpret the law. There's case law in my state that says that. Arbitrators do not have to explain their reasoning or decisions. Arbitrators are private persons, not public officials. They're not subject to judicial review, which is largely true. It's extraordinary to find a reason to overturn it. A bad or erroneous decision by an arbitrator cannot be corrected by anyone and must be enforced by the courts. They're often selected from a small group of people who are regularly employed almost exclusively in the private sector, and they're not really accountable for anyone for their decisions. If I get a state trial court judge who gets it completely wrong, the Supreme Court's going to yank their chain, or they're going to pay for it the next time there's an election in the General Assembly, but they're accountable. So how about this? What if they order you to spend money and you don't have it because it wasn't appropriated? Did you agree to a high-low? One of the things that the Department of Justice recommends, that before you enter into a arbitration, you agree on a maximum amount the arbitrator can award, because you want to make sure you have the funds in your hand to spend it. So there is some guidance that the U.S. Department of Justice at one time put out that I've listed in your materials that I recommend to you as useful in this context. So, almost done. Talked about choice of law. All right. So I think one of the things that I learned late in my practice was this idea of the overlay of appropriations law, fiscal law, on top of public procurement law. And it wasn't until I started to go to public contract law section events and started to hear about some of this stuff that I realized there was an overlay. And I don't want to go too deep into it. The stuff that's going to help you most is just to be aware in the third bullet that if somebody brings you something like a lease purchase or an installment sales contract, right, you need to be thinking about that and think, what's the fiscal law overlay? Is it crystal clear that after the end of the first fiscal period that all our obligations are subject to non-appropriations law? Right? And then be aware if somebody brings you a contract that doesn't have a non-appropriations clause and it goes on for multiple years, well, is there authority for multi-year contracts? And do we have the money in the bank for that? Those are important points. They don't come up very often, but what the courts in some states will say is it goes beyond, I get it picked back up, it goes beyond a fiscal year and there's no non-appropriations clause in it, you've created debt. And debt violates the state constitution, and that's a problem. So the model procurement code, by the way, has express statutory authority for multi-year contracts with a certain framework, but it also has a specific non-appropriations clause, which would be implied by law in case you forgot to put it in there. The other point I want to make is if somebody asks you to opine on this, right, look at the law in your state, because one not uncommon concept is as follows. General authority to build buildings and general authority to enter into contracts, which many agencies have, is insufficient to give them authority to borrow money or to enter debt beyond a fiscal year. In fact, many states have statutes that specifically say it's illegal, if not a crime, to enter into a contract for which you don't have the money in hand. That's already, you have the money in hand and it's been appropriated, or you can't spend it, which are different things. So be aware if you find yourself looking at one of those contracts. And the other point is there are some courts that say agencies only have the authority that is expressly given to them or necessarily implied, and that the courts are very reluctant to imply that you have the authority to borrow money, right, or to spend money you don't have. The feds have what's called the Federal Anti-Deficiency Act. I'm just going to have to skip over that. What was the last couple of points I thought were really worth making? Same concept on mortgages and liens, right? If somebody's going to grant a security interest in property that you're buying, if somebody wants to give a mortgage on some property, Be aware, where's the express statutory authority for that? Courts are very reluctant to find that implied. There'll be an AG opinion in your state almost certainly on that idea, and find it. One last point. A short story, and I got 1 minute to tell it. We had a statewide contract for testing services for all our kids. And I looked at the solicitation, and the vendor wanted to have terms of service, which is contract terms, that every employee of every school district in the state that clicked to a screen would be bound by individually. And every student, every one of your children that goes to a public school, if they were in my state, would have to click on those agreements. And they had terms like, we'll have disputes here, and this law will govern, and you'll indemnify us, right? And I just went postal. Department of Education didn't make a big deal out of it. I just went nutso. And I said, we can't do that. We can't do it politically, but I'm not going to sign off on it. And so we now have contract terms that say you can't do that. And it's a liquidated daily damage if you do it. What's the point of that? The point of that is there's always going to be some new issue. And you're on the forefront. And I encourage you not to be hesitant about bringing up issues to your chief procurement officer, your client, and saying, this is a problem, and if it's happening here, it's happening elsewhere. Can I be part of the solution? Is this something you want to take up and address, or do you want to let it slide? But you will see many things that you could find a solution for and work it because you are kind of in a unique position. Take advantage of it. Be a partner with your chief procurement officer. It's always a pleasure. Thanks, guys.